Are you ready? You're ready.
Ready?
Yep. Judgment, really unfair and another.
I hand down judgment in this case, neutral citation number 2020 EWCA Civ 1400 for the reasons set out in the judgment which the parties have seen in draft. The appeal in this case is dismissed.
Appeal in the matter of Solaria Energy UK Limited and Department for Business, Energy and Industrial Strategy.
Yes. May it please my lords and lady. I appear for the appellant in this matter. I don't know if Mr. Weisselberg and Mr. Howard appear for the respondent.
Yes. I was going to say, if you'd prefer to take your mask off, I'm sure that would be probably easier for us to hear you. It would be much more comfortable for you. So
Grateful, my lord.
But good.
It's our case that it's plainly arguable, following the findings in the Freya litigation, that insofar as Solaria had an A1P1 possession, they were interfered with in a manner that amounted to a breach of A1P1.
Yes. Sorry, just before you go any further, Mr. Adams, I just wanted to check whether you had a word with Mr. Weisselberg about dividing time up between you today, or obviously we have the 1 day, but that can't be extended, and you will need to bear that in mind.
My lord, I will bear that in mind. We haven't agreed a timetable, but I will certainly try.
Well, I would have thought you should aim to be finished by lunchtime at the latest.
I was certainly hoping to be.
Okay, good. Thank you.
The defendant department argues that such interference was justified, and maintains that that issue would still be open at any trial. But if it's not to fall at the first hurdle, I apologise, my lord, I've jumped right in halfway through my submissions. If I could start again.
Yes, and we've read the skeleton arguments and at least some of the main authorities, so you can take it we do know what the case is in the broad terms about.
My lord, I'll take it very shortly. The Feed-in Tariff Scheme was a government scheme to encourage small-scale solar installation.
Yes.
It required electricity companies to buy electricity over an extended period from suppliers whose installations have been accredited in any particular year. And they would then be paid in accordance with a table of rates published in advance for that year.
Yes.
My client Solaria is a supplier of solar panels and associated equipment for such installations. In 2011, it had a subcontract with a company called GB Building Solutions, which I refer to as GBBS, which had itself been contracted by Northumberland County Council to make small-scale solar installation on its own stock of dwelling houses and commercial buildings. The NCC already had property rights in their buildings on which they could install these installations. In respect of each accredited installation, Northumberland County Council expected to be paid for electricity supplied at the published rates in accordance with the scheme and planned its installations accordingly. On 27th of October 2011, which is 4 days before the proposal, Solaria had a legitimate expectation that it would earn the profit on the balance of the supplies it would make before 31st March 2012 under its subcontract with GBBS. It had a legitimate expectation that the public authorities, in the form of the courts, would assist it, if necessary, to enforce its existing contractual rights. It did not expect anybody acting on behalf of or purporting to act on behalf of the public authority to interfere with them. GBBS was itself employed by Northumberland County Council, which had a legitimate expectation, as I mentioned, that it would be paid at the published rates in relation to the installations. In light of that expectation, NCC, Northumberland, decided to increase the number of installations by 300 dwelling houses, from 400 dwelling houses to 700 dwelling houses, in addition to the 130 commercial buildings on which it planned to install solar. And it had decided to obtain those supplies from Solaria. It follows that as at 27th October...
Sorry, so NCC decided or GBBS decided that it should be Solaria?
Well, it was ultimately NCC's decision that was taken at a meeting with GBBS on the at a minuted meeting on the 27th of October 2011. It may well be that they could have, they had control over the supplier in any event. We say it follows that as at 27th October, Solaria had the legitimate expectation that it would earn its profit, being paid at the contractual rates under its subcontract, on in 700 houses and 130 commercial buildings, and indeed my Lord Justice Coulson, sitting at first instance in Brea, found, albeit on assumed facts and not on the specific terms of any particular contract, that the claimants with similar contracts to Solaria's had such legitimate expectations, giving rise to A1P1 possessions. On 31st of October 2011, the predecessor of the respondent department and its officers published what was described as a consultation document that foreseeably, indeed deliberately, threw the entire industry for the supply of installation of photovoltaic panels into confusion, without offering to pay any compensation to those affected. The proposal was to reduce the feed-in tariff by more than 50% on installations that were not accredited before 12th December 2011. In other words, bringing the date forward from the 31st March 2012, and indeed to a date that it was before the end of the consultation which the proposal envisaged. As a result of the proposal, NCC effectively decided to abandon the project in relation to installations after the 12th of December 2011. It aimed to do as many as it possibly could before the 12th of December 2011, but abandoned those afterwards, unless GBBS could renegotiate the subcontract with Solaria to reduce the price of its supplies. Well, this is where I started. It's plainly arguable, following the findings in Brea, that insofar as Solaria had A1P1 possessions, then they were interfered with in a manner that amounted to a breach of A1P1. As I say, the department argues that that was justified and says that that point remains open, despite what was said in Brea and the Court of Appeal. But if the department is not to fall at the first hurdle, it will first have to establish that what it did was a lawful exercise of its powers of consultation. In particular, the exercise was undertaken in good faith for proper purposes. And only if it can overcome that hurdle can it seek to maintain that it was proportionate and reasonable to make the proposals without offering any compensation for the foreseeable interference that it anticipated. And that is a point and an issue that could equally arise in private tortious proceedings, for instance, for unlawful conspiracy or inducing a breach of contract. It's a basic Enterton-Carrington point, rule of law point, that the burden is on the public officers to prove that their actions were an exercise of public authority and not the other way around, and would therefore have to be pleaded and proved in defence in this case, if it were to proceed. If the actions were not lawful, then on the face of it, they would be an interference with the private rights under the contract and might well be tortious at common law in any event. Venture to go into the territory, but it is a fundamental principle that the Crown as a political institution can't do any wrong. As Blackstone observed, it's a necessary and fundamental principle of the Constitution, with the consequence that at common law, public officers are personally accountable for conduct, for unlawful conduct, not the Crown, and any liability of the Crown is vicarious. Furthermore, insofar as the claimant had a substantive legitimate expectation that the feed-in tariff would remain the same until 1st of April 2012, then even if it was strictly lawful to publish the consultation, it might even at common law, be considered an abuse of public power or an affront to the public conscience to assert in the proceedings that there was any lawful exercise of power, which is a matter that the claimant would raise in reply if it were to be asserted in the defence that it was lawful to publish the proposal. Again, if such issues arise in private proceedings, then they must be dealt with as and when they arise, and as a matter of principle, the situation must be the same in relation to HRA claims.
Do we really need to go into this much background, Mr. Adams? I mean, the issue that we have to focus on is the A1P1 point.
Well, my lord, yes.
And the limitation.
My lord, yes. It was only really by way of background and to understand the nature of the right to bring a claim under the HRA Act. Perhaps it's more relevant to the second point on limitation.
I mean, here we have a statutory right under the Human Rights Act to bring a claim where there's an infringement of A1P1. So do we really need to go into any more constitutional detail than that?
Well, my lord, it is relevant to the analogy with tortious claims and whether this is in fact a tortious claim. I think the HRA hasn't granted, insofar as Parliament was able to, direct rights to claimants, as I understand it, save insofar as they are entitled to bring claims under the Act, and it will be, and my lord, that would be relevant as to whether or not there is in fact a 6-year limitation period, or whether in fact the limitation period is unlimited.
I mean, there isn't a 6-year limitation period.
Well, my lord, nobody suggested there is. Is that?
Well, exactly.
Yes.
No, but my lord, I was only trying to put that in context.
I mean, you may argue there's an analogy with the 6-year limitation for claims, which should somehow inform one's construction and application of section 7. But
my lord,
the claims we're dealing with in this case, surely, are ones for infringement of the A1P1 right under the statutory jurisdiction conferred by the 1998 Act.
yes, and whether there's any defence to that would go to merits.
Well, but we don't alter that, do we? I mean, we're just concerned with the primary threshold question of whether your clients had possessions within the meaning of A1P1.
My lord, that's certainly what I'm going to take first.
Okay, I mean, that's one of the two big issues we have to grapple with, on which the judge below gave his judgment on. So I'm not really clear at the moment why this wider excursus is really going to help us very much.
Well, my lord, it was only that there was some discussion in Breyer as to whether it was lawful to publish the proposal.
We're not concerned with that, are we?
Well, my lord, in my submission, we will be if we get to limitation, because the question of limitation has to be considered in all the circumstances. I think it's common ground that one of the circumstances is the merits of the claim.
Yes.
And when we get there, I'll be saying that, if I get over the A1P1 point, I'm saying that, the judge really his views were expressed on a rather artificial basis. And my first point on that will be that he couldn't at that stage make the determination. But
well, perhaps it may be better to return to that point when we get on to.
My lord, yes, these are really only introductory remarks. The consequence of the proposal was that unless a new arrangement could be agreed with GBBS, then it could only expect, subsequent to the proposal, to make a profit on the number of installations that could be made and accredited before 12th of December 2011. That was the position immediately after the proposal was made. It had gone from 700 plus 130 down to whatever could be done before 12, which practically was a very much smaller number than even the number of houses and buildings envisaged under the original contract, let alone as extended by the NCC's decision on the 27th of October. As to the damage in respect to which it seeks satisfaction, it's Solaria's primary case, the difference between its expected profit before the proposal and its expected profit afterwards, which was drastically reduced, is the prima facie extent of its damage. Under the contract, the claimant would have been paid, as had been the case up to that point, shortly after delivery out of sums paid by NCC to GBBS. So there'd be no question it'd be paid almost immediately for the supplies it made at the full contract rate. The effect of the proposal was that NCC decided not to make the installations, and at that point, Solaria had lost its entire expectation of making any profitable supplies after 1st of April. After
What was that point? You said at that point. What's the date of that point?
Well, I'm not sure I can give you an exact date because it was beginning of November.
November
2011.
2011. Thank you.
Insofar as I was able to rescue anything from the situation by renegotiation with GBBS and make subsequent recoveries from then on, insofar as such sums are properly to be brought into account at all, we say they represent mitigation of such loss. Now, to a certain extent, it probably doesn't matter, because as Lord Justice Mustall said in Hussey and Eales, whether you analyse it as causation or mitigation, the problem raises the same issues and leads to the same conclusions, and is ultimately a question of fact as to what damage was caused. But the burden will effectively again be on the defendant to raise an issue that there was any failure of mitigation, and the scales are weighed heavily in favour of the claimant when considering the reasonableness of the claimant's actions. And again, courts routinely deal with such matters in private law claims for damages, and there's no reason to suppose that similar considerations would not apply to the discretionary award of compensation under the ECHR. The issues in the appeal are firstly A1P1 and then secondly limitation. I rely on my skeleton argument, which your lordships have.
Yes.
Taking A1P1 first, we say that A1P1 should be construed autonomously, purposefully, and giving primacy to substance. And the essence of A1P1 is to protect things which a person actually has from interference by, or purportedly by, public authorities without reasonable justification. And my Lord, Lord Hobhouse in Aston Canlow, which is in the bundle at tab 11, made the observation that it applies to all forms of property and is the equivalent of assets, things somebody has.
But we don't need to worry about that either, do we? Because this particular possession, subject to the assignment point, has been found to be a possession under A1P1 by the Court of Appeal in Brer.
Yeah, well, strictly, I think probably by your lordship at first instance,
Well,
because I don't think the contract...
I'm not bound by myself, but I am bound by the Court of Appeal.
I don't think the contract points were appealed, in fact, but yes, just any concluded contract was confirmed by the Court of Appeal to be the right side of the line.
I mean,
and it is therefore only the assignability point.
Yes, I mean, you start off with the prima facie powerful point. You have a concluded contract of commercial value between yourself and NCC. And the next contractor up the tier from you, which is of obvious commercial value. So why is that not a possession, you might ask?
My lord, precisely. We say a common law was a shows in action. In other words, we were entitled to come to court to have it enforced, which was the first point I made. That was our prima facie position. Yes. Our legitimate expectation is that the public authorities would help us enforce it, not take it away. My lord, it was only a comment in, I think, my Lord Justice Coulson's judgment at first instance, that one would have to look at the individual terms of the contracts and the assignability of contracts that opened the door to this argument.
Yes, well, of course we have to look at the jurisprudence and see what, as you say, rightly say, the autonomous test which the European Court applies in deciding what is a possession. But as I say, on the face of it, one feels intuitively, if a valuable commercial contract of this nature is not a possession, well, why should that be?
My lord, yes. And I will have to sort of go slightly wend my way through some of the older authorities, because in my submission it has got confused in the authorities, in some of the obiter observations that have been made in some of the authorities. And my lord, and essentially we say assignability is relevant to the question of whether something like a license or a permission, which doesn't have any value in itself, on its face, can be an A1P1 possession, but it has much less relevance to something of present economic value that a party actually has.
And even if assignability is relevant, and certainly I'm not suggesting it isn't, but we're dealing here with a contract, as I understand it, which was assignable,
yes.
Albeit with consent.
Yes.
And indeed could also be sublet. I know that's not quite the technically correct term, but could be sublet with consent, not to be unreasonably withheld. So either way, the possibility of assignment was expressly contemplated by the contractual terms you entered into.
Yes, the benefit of this contract was an income stream, a money benefit, which at law is in its nature assignable. On the face of the contract, anticipated it would be assignable. And one can contemplate a variety of transactions in which that future expectation of income could be capitalized, at least to some extent, in the short term.
Yes, I mean, even if it's not assignable at law, as you say in your skeleton argument, there are other ways in which it could be turned to account in a way which was of value to your client. So
yes.
Again, that makes one wonder why assignability should be the touchstone when one can achieve an equivalent effect in different ways.
Yes, and I can certainly declare a trust of the income stream and sell the beneficial interest, realised in some way immediately. my lord, so firstly we say yes, the contract is a chosen action. It's in its nature assignable. And is therefore an item that would be recognised as property common law. And it is the right side of the line as far as A1P1 is concerned. It's something valuable which can be interfered with. One can add to that the point that I think my Lord Justice Coulson made most clearly at paragraph 106 of his judgment at first instance, that this wasn't just a private contract, it was a private contract that was made on the back of a scheme published and encouraged by the public authorities that certain rates would be paid to suppliers for installations made before the 31st of March, and all the private parties had arranged their affairs on that basis. And practically, it was going to be almost impossible for the government to lawfully bring the date back much before 31st March 2012, even if there was, even if that could be lawfully done. There's an argument, there's a substantive legitimate expectation that would prevent the government making any lawful order before 31st March 2012, and even if they could, they couldn't bring the date back very far.
I mean, that was the issue, presumably, in the judicial review proceedings.
The issue in the judicial review proceedings was strictly that what was proposed would have retrospective effect, which plainly cannot have been anticipated. And would therefore be unlawful if implemented.
Because it was ultra vires. The power. The way the Court of Appeal put it was that if the proposal had been implemented, if an order had been made, then that would be ultra vires, yes. But it left open the question of whether simply making this statement in the market deliberately, knowing it's going to interfere with everybody's business, was a lawful exercise of public power, which is, I think, where I was going with my slightly discursive return to Entick and Carrington. Because on the face of it, if a public body interferes with your private rights, it's for them to prove they've got a lawful basis for doing so. And that would be... and if they haven't got a domestic lawful basis for doing so, then they don't get off the ground on justification.
Right, so where do we go from there, then?
I think this... And as your lordship's already made the point, we don't need to go much further than Breyer in terms of establishing, for the purpose of these proceedings, on the very facts in issue, that this is potentially A1P1 possession. We do say that, and we say that the relevant contrast that is drawn, if one looks at the cases carefully, a relevant contrast is between things that are purely personal to a person, which Article 8 may protect, and things which a person has, which fall under A1P1. And that's a distinction made at common law between purely personal matters and property. And therefore, some of the questions that arise in the cases is whether the interference is with the personal livelihood of a person, or whether it's with their assets. And we say it's in relation to that question that assignability may be relevant, because if you can't assign it, it may be an indication that it's something purely personal.
Yes.
Another claim, another question that arises on the cases is whether what, under the ECHR jurisprudence, the claimant has what is known as a vested claim. And that is whether claimant has something that would be legally regarded as property, or at least a substantive legitimate expectation of continued enjoyment of an existing asset or trade connection. Okay, the case is most directly relevant to the sort of personal proprietary question. Countryside Alliance, which dealt with mere livelihood, that was the hunting with dogs case, in which observations were made, and the article, and Murunguru, which was the case where Mr. Justice Lewis and Lord Justice Sedley considered whether there was a chosen action for the gentleman who was trying to come to the country to have personal medical treatment. The cases relating to legitimate expectation of continuing to enjoy existing economic benefits that arise from past actions include Exton, Germany, Battalan, Van Marl, Ian Edgar, and to some extent, Nichols.
Why are any of those relevant to the issue we have to decide about whether or not a prohibition on assignment, if that's what it is, makes this not a possession?
Because I think the argument was that it was this falls within the autonomous meaning of what we were expected to earn under the contract was within the autonomous meaning of future income. But my lord, in my submission, we don't have to go that far. We say contract is an A1P1 possession, but it's a fortiori an A1P1 possession because it's a contract plus a legitimate expectation that you will earn that, you will actually earn that income under.
I mean, Murunguru is obviously more relevant because there is some question there about, I think the word is transmissibility. Yes. So I can see that. So we probably need to look at that. But at the moment, I don't sure from the narrow point in front of us that we need to look at the cases about legitimate expectation. But possibly I'm wrong.
Well, my lord, they're very short. This is very dense. The ECHR cases are short with very dense language. But and my lord, I don't think any of the English cases went back to the sort of the starting point of those cases. I'll try and deal with them shortly. Exton, Germany, tab 3 in the authorities bundle, was a case where notaries were paid fees at prescribed rates, and the question was, that the regulations changed, and the notaries weren't going to earn so much in the future, and it was claimed that they had an A1P1 possession. The relevant passage is bottom of 219 over to 220. However, a notary's claim for fees can only be considered as a possession. This is the marked passage at the bottom of 219.
Yeah.
In the meaning of this article, when such claim has, in a particular matter, come into existence on the ground of services rendered by the notary and on the basis of the existing regulations for notary's fees, the mere, and I emphasise the word mere, expectation of notaries that the existing legal regulations on fees will not be changed in the future can, on the other hand, not be considered to be a property right. as the Commission just found, the applicant's expectation the regulation of fees on for notice would remain unchanged did not constitute a property right within the meaning of A1P1. Question of discrimination with regard to the rights guaranteed by this article consequently does not arise. So the rationale was you're only earning this because of regulations, but those regulations could be lawfully changed at any time to take your right away, and therefore you didn't have any sort of legitimate expectation. You continue to earn the sums you were only earning because of those regulations.
Yes.
The next case is Batalan, which is this was a case of a professional.
So which
Sorry,
tab is
tab
that?
5.
Oh, tab 5. It's a license case where a doctor had a license to dispense medicines in an area where there was no dispensing chemist. Such license was withdrawn as the area was subsequently declared suitable for a dispensing chemist. And the question that identified by the court was whether the license can be considered to create for the license holder a reasonable and legitimate expectation as to the lasting nature of the license and as to the possibility to continue to draw benefits from the license activity. And that's, one sees that from the bottom of 172 over to 173. And the question is identified at the top of 173. The question whether the license can be considered to create for the license holder a reasonable and legitimate expectation as to the lasting nature of the license and as to the continued possibility to draw benefits. And again, in that case, they found that the license was withdrawn in accordance with its terms. So there was no A1P1 possession. And
I mean, that's hardly surprising, because if your license is revocable in certain circumstances, well, you can't have a legitimate expectation to those circumstances not arising.
no, exactly, yes.
I mean, this is really pretty obvious, isn't it?
Well, my lord, yes, but in my submission, this is what these cases, that's the question these cases are looking at.
Yeah.
Whether or not, because of what somebody's done in the past, they have a reasonable and legitimate expectation of continuing to earn. And there are professional cases, for instance, of doctors who have obviously spent a lot of time and effort qualifying as doctors, building up a clientele, and then it's been held that...
But I mean, none of this really goes to anything, does it, other than your potential claim in relation to the additional 300 properties? Because for all the rest, I mean, you have your contract, so we don't need to look at legitimate expectations.
Well, my lord, I have the contract, I say, in relation to the 300 as well, because they were to be ordered.
They force you all right. We don't need to be looking at cases about legitimate expectations.
Oh, my lord, I think I probably... My lord, one can then follow through. I won't take you to them, but there's Van Maal, which I'll just mention them. I
mean, Nichols has a very valuable and detailed exposition of the law, doesn't it, by Deputy Judge, as he then was.
Well, my lord, I'm not sure he was, right. but his comments about barristers not having A1P1 possessions effectively is where it was not the ratio of the case, and in my submission is inconsistent with these earlier ECHR.
Okay.
And that, I think, is where there's been considerable confusion in the subsequent cases.
I may have got this wrong, but I thought his analysis had been approved.
Yes, in relation to a pure license. And my lord, perhaps I will. It's a difficult point, but I think it shows why this has become so confused in the case.
Well, I mean,
some of the observations.
Let's not go there if it doesn't matter, and we're not concerned with a mere license here on any of you.
No, precisely. but my lord, I think if I can just, I'll just very shortly summarise the cases. Van Maal was a professional accountant. A scheme of regulation was brought in, which affected his personal opportunity to continue to earn income. It was found that that was an A1P1 possession, but the public authorities were justified in taking it away. I've mentioned Big Ava, which is a case that was decided post-Countryside Alliance, which suggests that if a state encourages somebody to spend a lot of time and effort trying to get a professional qualification and then refuses to give them the professional qualification, that could be Article 8, not A1P1. That's just drawing my distinction between A1 personal rights and property rights.
I'm sorry, I'm not sure I got the name of this case. What's it called?
There's only a note of it in the bundle.
Oh, I see. It's 23 in the bundle. Is that
23, yes. The original judgment's in French, okay. But it was the Russian trainee barrister in Greece,
yes,
who was encouraged to take a degree and study for her exams, then wasn't allowed to take them because of her nationality, and that was held to potentially be an interference with her Article 8 rights, because she hadn't any sort of established practice. She didn't have, but she interferes with her personal livelihood that she wasn't going to be able to practice in the future.
Yeah. Thank you.
Ian Edgar, the important point to take from Ian Edgar is that the claimants, this was firearms legislation in the UK.
Sorry, which tab are we at?
Tab 8.
Yeah.
But my lord, I think I can just make my submissions without having to turn it up.
Yes, I guess want to get the name of the case
outright. The claimants were paid various heads of compensation, including for their stock, together with a 25% uplift on their existing stock to compensate them for lost profits in respect of such existing stock. So they were compensated not just for the assets they had in stock, but an element of profit on top of that. The claimant complained that it was not compensated for the loss of its business more generally, and though the court didn't have the information to sort of fully analyse out what they had been compensated for, what they hadn't, they took the view that there had already been some compensation for loss of goodwill, and they said there was no legitimate expectation of continuing to trade in the manner they had been, not least because there had been repeated legislation since 1920 regulating the market, so anybody in that market could expect there to be regulatory changes. Countryside Alliance was the hunting with dogs case, and observations in that were relied on in Nichols and Malik. So it may be that we had to take this slightly slower. If one turns up at first instance judgment, tab 14.
Do we really need more than the familiar passages in the House of Lords, Lord Bingham and...
Well, my lord, I think essentially all Lord Bingham decided or didn't even decide, I think as my Lord Justice Coulson made the point of first instance in Breyer, even his observations were merely obiter. But what he essentially did was identify Malik as a license case. Yeah. Because as we will see, Malik had a contract, but there wasn't any significant interference with his contract, and he didn't make the claim on the basis that there had been any interference
interference with his contract. He made the claim on the basis that he had a separate license, effectively, to practice as an NHS doctor.
Yeah.
And I think what Lord Bingham is making clear in Countryside Alliance and the House, I think it was House of Lords,
Yes.
was that the analysis was right in relation to a mere license. If it's not transmissible, if it doesn't have any value in itself, it's not an A1P1 possession.
Yeah. If I'm thinking of the right case, I mean, the point was that because of the statutory prohibition, of the goodwill of a doctor's practice, that therefore had no value and couldn't be treated as a possession.
Well, my lord, it wasn't. That was the essential. That is the essential point, which is why it makes it a difficult case, because that suggests it was something to do with his not being compensated for his established practice. The analysis that I think Lord Bingham approves is that, and if one looks at the Court of Appeal carefully in Malik, the way they decided it was actually a license case. It was a mere license case, and the license itself did not have any value. My lord, one does have to weave through it slightly carefully.
I mean, the reason it had no value was because of the statutory prohibition on assignment of goodwill, wasn't it?
Well, no, it just wasn't. It wasn't assignable at all. A license to be on an approved doctor's list was not an item of property in any sense at all.
Yeah.
That's the ratio of the decision, particularly if one looks at I think Lord Justice Moses and the passages he identifies in the other two judgments, Lord Justice's judgments with which he agrees. That the headline statement is that there was a statutory prohibition on realising goodwill, but in fact, and the point, my lord, perhaps if we go straight to Malik, which is tab 17. And my lord, perhaps if one glances forward at tab 18 and Lord Bingham at 21 of Countryside Alliance, what Lord Bingham says is, in R. and Malik, Court of Appeal held that the inclusion of Dr. Malik's name on a list of those qualified to work locally was in effect a licence to render services to the public and being non-transferable, non-marketable, not a possession for the purposes of Article 1. And I consider the Court of Appeal reached a correct analysis on the convincing analysis of Mr. Kenneth Parker in Nichols. Now, there are the analysis in Nichols both goes perhaps slightly wider than just license. The ratio of Nichols was just the license point, a mere license that is not transmissible and has no economic value in itself, is not an A1P1 possession. My lord, Lord Bingham is making clear there that is the ratio of those cases.
Sorry, could you just say again what you say the ratio of those cases is?
There's a mere license that has no economic value in itself and is not transmissible for value, a mere permission, would not be regarded as an item of property at common law and is not an A1P1 possession. It's only if it's only if the license is coupled with an item of property and there is a reasonable and legitimate expectation that it will continue, that it becomes relevant as to whether or not there is a A1P1 possession. But then it's not the license that's the A1P1 possession, it's the effect of the license on something else.
My Lord, if going back to Malik at tab 17, if one starts at paragraph 7 in the marked passage, it's explained that a doctor on the performers list has a contract with the commissioning body that pays him sums in accordance with regulations. And as pointed out at C, these contractual arrangements have their own mechanisms for payment, variation and termination, independently of the suspension or removal of a doctor from the performers list. In this case, Dr. Malik entered into a contract with the PCT as a sole practitioner. His contract remained in force throughout the period of his suspension. Paragraph 13, during the suspension thereafter, he voluntarily refrained from practice and he was continuing to be paid pursuant to his contract, subject to a 10% deduction that I've mentioned. And then 15, the sole issue in the appeal is whether the PCT's unlawful suspension of Dr. Malik amounted or gave rise to a deprivation of possession, so as to engage A1P1. Then if one looks at the judgments, Lord Justice Old sort of deals with the Law 21 following and mentions some of the cases that, including some of the cases I've already mentioned. Then at 23, there's this reference to the goodwill of an established client base with his own inherent, and this is where one gets references to inherent market value from future earnings prospects from existing circumstances, since the existence or valuation of goodwill will turn at least in part on projected future earnings. However, no such blurring of the line can occur here, since Dr. Malik's clientele and the form of patients registered with him has no economic value and so cannot constitute a possession because of statutory denial to him of any marketable goodwill in his patient's list. That is an observation and is not, I think if one looks carefully, the ratio of the decision. Because it's if one looks in particular at Lord Justice Ricks at 68 following, Mr. Justice Collins at first instance had found that inclusion in the performers list was a license and was an A1P1 possession.
Yes.
And at 68, Lord Justice Ricks says, the first question in the light of this reasoning and submissions on appeal is whether the analogy between inclusion on the performers list and the grant of a license is accurate and helpful. In my judgment, it's not. As Lord Justice Old has shown, licenses come in all forms. Some licenses are valuable assets in their own right, such as a fishing license attached to a vessel and transferable with it. It may be that planning permissions fall into that category. Other licenses are valuable only in the sense they give value or greater value to some other asset. In such a case, the jurisprudence considered above shows that the possessions in question, which need to be considered, are the underlying assets, not the license. You see also Carney. and he makes reference to the doctor's vested interest in his practice, which are being closed down. And in paragraph 70, that analysis, in my judgment, is consistent with propositions that A, licenses may differ from one another in terms of being possible subject matter of A1P1. The license may itself fall to be distinguished from economic interests which underlie or derive from it, which are themselves to be treated as possessions. And C, a license or permission or qualification to seek a particular type of employment may not be a possession. And then he considered at 72 that in the present case, inclusion on the performance list is not a license in itself, but a condition precedent to being a doctor to perform services. And he points out that if suspended from the performance list, the doctor does not thereby lose his contract, only his ability to provide services under it by way of personal performance. '73, the judge did not say that inclusion or non-suspension from the performance list was a license, but that it was akin to one. In my judgment, however, this analogy does not suffice to render Dr. Mallett's temporary suspension interfere with his possessions. Even a license may not be a possession, and the analogy therefore breaks down. It seems to me that inclusion on the performance list is a matter of regulation, a condition of qualification rather than possession, property right in itself. And as the Lord Justice Alders observed at 44, one cannot readily speak of the inclusion on the list as an economic asset. It is not an asset. It has no value, monetary value. If one was looking for possession in this context, one would look naturally to the NHS contract. But that remained on foot and is not the subject matter of Dr. Mallett's claim under the A1P1. So that, and if one then goes back to what Lord Justice Ald said at 40, in my view, good sense and Strasbourg domestic authorities require separate consideration of claimed future monetary entitlements from a claimed future entitlement based on a personal interest and enjoyment of it, but not involving any monetary claim. When considering a claimed future monetary entitlement derived from an instrument such as a license or permit, the court should focus first on whether the entitlement has present economic value to him in the sense of being marketable by him. And then he gives the example of legal in general. The corollary of that reasoning would appear to be that the license itself is not the possession, and that whether the economic interests that flow from it are a possession depends on the facts, one of which may be the marketable goodwill that can flow from the exercise of a licensed trade, in effect, the Van Maal or trade tactora type cases. And if one looks at Lord Justice Moses, paragraph 86, he agrees with the reasoning of Lord Justice Ricks at paras 59 and 66, and Lord Justice Ald at the paragraph I've just read, which was the paragraph that Lord Justice Ricks agreed with, which is the point about it's not generally, unless the license is assignable in itself, it's not usually the license that is the possession. It's the underlying asset, which in this case would be the contract, that was not claimed because it had not been interfered with. If one looks at 59 and 66, in Lord Justice Rick's judgment, he's talking about the distinction between goodwill and mere future income. He says, in this passage, the court seems to be saying that for the purpose of distinguishing an existing possession with goodwill consisting in clientele and a mere expectation of future income, the substantive rather than the formal test will be applied. Thus, there will be no interference with possessions within Article 1P1 if the value of a business declines only insofar as future income is anticipated. And he says the practical difficulties of this distinction did not have to be explored in that case. And at 66, the difficulty between the distinction between marketable goodwill and mere future income does not need resolving, for as Lord Justice Alders pointed out, the goodwill has no economic value because of the statutory prohibition. But that's the reason that point didn't have to be decided in the case. It's not the ratio of the case.
So what do you say for this case that we get from all of those citations in a sentence?
If one's looking for an A1P1 possession, one is looking for the contract.
These cases aren't about a contract.
Well, Malik was, as Lord Justice...
they're not about a contract, they're about a licence.
Well, that's the point Lord Justice Rick says in Malik at 73. If one was looking for an A1P1 possession, one would be looking for the contract.
Exactly.
So the A1, what one gets from these cases is that these are concerned with with licenses, permissions, that type of, not what one would traditionally think of as a shows in action. The underlying contract in both Malik and our case is a shows in action.
Yes, so which we get from this is that these are cases about licenses, which is not our case.
Exactly.
Right, and that's why you say assignability or transmissibility was relevant, but it's not necessarily relevant in relation to the underlying asset.
It isn't some sort of legalistic hurdle one has to jump over in respect of all A1P1 possessions. It is something that is relevant if one's looking at the question of whether a license or mere permission is an asset. Now, assignability may go, as one sees from Murungaru, as to whether or not one has a shows in action, because something that is purely personal is equally not a property right. But something which is in its nature, in our case, we have something which is in its nature is a shows in action, which is as my Lord Justice Henderson has pointed out, is in its nature assignable on it is only an income stream, and its benefit can be realised in any number of different ways. So these cases are simply not relevant to the analysis of whether our case is an A1P1 possession. And if one looks at Murungaru, and therefore the judge was wrong to base his conclusion that we did not have an A1P1 possession on his equivalence between the statutory bar and assignment in our case and the regulatory bar in Malik. Not only was that not the basis of the Malik decision, but in Malik, because there was a regulatory bar, insofar as those observations are relevant, the doctor never had anything to be taken away because the regulations had already taken it away. If one has the accountancy type case, which is the Batalan case, sorry, I think it's Van Marl, then the established practice can be an A1P1 possession, and if you regulate it and take it away, then that can be an interference, which would have to be justified. But on doctors in this country, their clientele is not something they can ever realise because of the statutory bar. turning to Murunguru, which is tab 20, this was the case of the Kenyan doctor who was refused entry and claimed that his inability to get into the country for his medical treatment was an interference with his A1P1 possessions. And the question posed by Lord Justice Sedley at paragraph 29 more to the point is whether a contract for personal services such as this can possibly rank as a possession for the purposes of A1P1. Surprisingly, this was not debated at either of the hearings below. Counsel then instructed the Home Office for the Home Office wrote, the defendants accept that contractual rights which are as shows in action are capable of being property for Article P1P purposes. Assuming that the first comma is meant to be there, the first proposition is simply wrong. By no means all contractual rights are shows in action. If the first comma and with it the second is there by accident, so the proposition is simply that those contractual rights which amount to shows in action are capable of being possessions, not property under A1P1, I will not, at least for present purposes, demur. It becomes immediately necessary to decide whether the contractual right in play here is capable of falling into that class.
But if a contract, if you're looking at a contract and considering whether it's a possession, do you always have to get to the same answer regardless of which counterparty you're looking at? So the acquisition of medical treatment by Mr. Murungaru was treated, I think, as personal to him.
Yes.
But what about the doctor who had contracted to provide the treatment? Would it automatically not be a possession for him, or might it be a possession? You see the point I'm asking. Is it always the same answer?
Well, that would his claim to his expected income under the contract be a possession?
Yes.
It might. My answer is it might be depending on the circumstances.
Well, that's what I'm asking.
And
Is it? You might. So you're saying you might, in certain circumstances, get to a different answer as to whether the contract was an A1P1 possession, depending on which counterparty you're looking at, and that must be because it depends on what the nature of the obligations or the entitlements under the contract.
I'd say it's what the claimant has. If he has something.
Well, he always has the rights under the contract. For Mr. Murungaru, it was the right to acquire the medical treatment. For the doctor, it was the right to...
I think the point was made that that wasn't a specifically performable right in any event.
Well, then you're asking a different...
I think it was a purely personal contract. If one looks at what...
Well, it was from the point of view of Mr. Murungaru, but it wasn't from the point of view of the doctor. And for a doctor, it was an engagement in his professional working life. And of course, it was personal in the sense the contract is to treat a particular individual.
Well, it was probably for him to treat.
But
if it was for him to treat,
yes, I'm sorry.
Then he couldn't say, actually, I've assigned the benefit of this contract to Dr. Y, and he's the doctor that's going to
have a look at the contract to see.
Yes, but
yes.
Yeah. Right, but
and whether or not it is purely personal would be is potentially a relevant question. One sees that from Lord Justice Lewison at 44 to 45. The classic definition of a shows in action, in talking to the McGee, is a personal right of property which can only be claimed or enforced by action and not by taking physical possession. To use this definition to decide whether a contractual rights counts as possession for A1P1 is to some extent circular, which is my latest point. If the rights that Dr. Murungaru enjoys under his contract are rights of property, they will be shows in action. looked at from the other end of the telescope, if they are shows in action, they will be rights of property. It's a necessary condition of the existence of a shows in action that there is a remedy for its enforcement. It's usually the case that a shows in action is something which is capable of being turned into money. And some of the characteristics of the contract in the present case are not in doubt. First, the benefit of the contract is incapable of assignment. Dr. Murunguru could not confer the right to medical treatment on anyone else. Second, a contract for personal services, as a contract for personal services, it cannot be vicariously performed. So this makes the point, my Lord, or just Henderson's point, that clearly in this case it couldn't be performed vicariously. Third, if Dr. Murunguru was to become bankrupt, contract would not vest in his trustee. If he died, his personal representative would be able to take advantage of the contract. Incapable of being enforced by injunction on a specific performance. No question he'd be paid for any medical treatment in advance. And I suppose from the point of view of the doctor, he still had, what he had before was a contractual right against Dr. Murunguru. What he had afterwards was still a contractual right against Dr. Murunguru.
Yes, I mean...
Which, insofar it had any value before he arrives and he performed any services, which it seems unlikely.
If he's entered into a contract to provide, a heart transplant, I don't know what it was to Mr. Murunguru. Certainly once the doctor has provided the heart transplant, then I think you would say there must be a possession in the contract, because then
you'd have a debt.
Entitlement to, it's a debt.
Yeah.
Whether it's a possession before he performs, but it's difficult to see how performance could translate something into a contract, into a possession which was not previously. But anyway, it may be
if the contract had any economic value before performance, then it still had that economic value, and it wasn't interfered with, I suppose, because he could have sued Dr. Murunguru, and so far as he had a claim for damages for not turning up, he could sue him for he could still assert his personal right against Dr. Murunguru to recover his damages.
Yeah. Yes, if Mr. Murunguru didn't turn up for his operation, the doctor would say, well, I've lost money because I would have done a heart transplant for someone else.
And you might then be in the difficult territory of whether that's a mere expectation of future income, which is not a A1P1 possession even if it was interfered with. Or would be treated as something he already had because of what he'd already made the client connection with Dr. Murunguru. And he had an existing contract. So one might well say that in those circumstances he did have an A1P1 possession. That if suppose that the legislation was passed to prevent the courts from him enforcing his case of action would be an interference.
But there you have an existing contract which is in place at the date of the alleged infringement. So, and from that point of view, the question perhaps is really whether the position is different before performance, when the most you have is a right to claim damages for breach of contract. If the patient doesn't show up, and the position afterwards, and you have a straightforward debt, which is obviously more straightforward. But both of those are to be distinguished from the situation where you have no contractual relationship actually in place on the date of the alleged breach, but you are hoping, maybe with confidence, that a profit will be derived from future events.
Yes.
And that, of course, definitely falls on the wrong side of the line.
Yes. In a sense, public authorities always have the right to regulate.
Yes.
It's a question of whether you have any legitimate and reasonable expectation that they won't legislate to take away what you've got.
Right.
And that's why, an existing contract, your expectation is it will be enforced, not that it will be taken away.
Yeah.
That is why it's a chosen action, because you have a legitimate expectation that public authorities will assist you in realising,
I don't
rather
find it
than
helpful to characterise this particularly as legitimate expectation. I'm just trying to identify what the elements are in a contract which distinguish it from a licence. I think we can all sense there's a distinction there. I'm trying to express it in words, and part of that is to say, well, for Solaria at least, what you expected to get out of the contract was money in return for providing goods, and that is therefore a possession. Whether it's also a possession in the hands of GBBS, who will pay out money in return for receiving solar panels, may be a question we don't have to go into.
I think the point my Lord Justice Coulson, one of the points my Lord Justice Coulson made at first instance in Breyer was it doesn't really matter how you arrange the industry, because effectively the government has agreed to pay a certain price, and then various players will be involved in the supply and installation of the goods and whatever else has to be done. NCC have roofs which are land, and the value of those was directly affected by the proposal. And they had employed a chain of other providers.
Yes, I think we've been through that in your introduction. It's not quite the point that I was addressing.
Well,
I think I've thought myself through it.
Well, my lady, it perhaps does come back to the legitimate expectation point, because the points are made in cases like Countryside that you don't necessarily have a right just to keep on, if you're employed, you don't have to necessarily have a right to keep on being employed. If you're just but this is what you're in those circumstances.
Sorry.
Yes,
it depends on the contract.
Precisely, my lord.
That's all we're concerned with. We have a contract here. It depends whether or not this contract is a possession. Depends on the contract.
My lord, yes.
It's not a question of legitimate expectation.
Well, my lord, my only point is it can be, and my lord, that was the point. I think your lordship made the point at I think it's 106 in Breyer at first instance. As a slightly alternative way of putting it.
Are we leaving Murungaru?
Yes, my lord, yes. Breyer at first instance is at tab 30 in second bundle of authority. Your lordship have been considering a sort of freestanding legitimate expectation argument, and your lordship had rejected that. But then at 104, your lordship does summarise findings in relation to contracts. The position in respect to concluded contracts is, I think, different. They were an asset that had been acquired by the claimants. They had a legitimate expectation that they could enjoy that asset by fulfilling the terms of the contract and being paid in accordance with its terms, or improving its business and goodwill as a result of the rights and obligations it contained. On the assumed facts, the defendant interfered with that legitimate expectation by creating a situation in which these contracts could not be performed. And then at 106, your lordship goes further and says, effectively a fortiori,
the position is different for contracts signed and concluded before 31st October 2011. In respect to those assets, there was a legitimate expectation of payment at the maximum rate for installations completed by 1st of April, because any possible reduction in the fit rates would realistically have been considered to be inapplicable to such signed concluded contracts. But this is because the due process identified by Section 40 meant the cut-off date could not be varied until there had been a consultation and a minimum of 40 days parliamentary scrutiny. By 31st October, in respect to those contracts, there would not have been enough time for the fit rate cut-off date of 1st of April to be significantly foreshortened. Moreover, the Minister had said on October 2011 that existing rates would not be reduced retrospectively, so in respect to contracts signed concluded by 31st October, I find there was a legitimate expectation of fit payments at the highest rate, which expectation could be described as certain. So there are two steps. One, you've got to show an action, which you can expect to be enforced and earn your profit. And two, not only in this case, because of what the government has said and because of the nature of its scheme, that you had effectively a substantive legitimate expectation that the prices wouldn't be paid until 31st of March or perhaps very close to that date. And we say that that is precisely our case. And A, the assignability is irrelevant to that, and B, as my Lord Justice Henderson has pointed out, this contract was assignable and could be realised in any number of different ways. Well, if I move on to, unless I can assist your Lordships any further with A1P1, we move on to limitation.
Yes, thank you.
My Lord, and this goes to some of my earlier comments, I think it is worth turning up Aston Cantlow at tab 11 for what Lord Nichols said about the nature of the purpose and effect of the Human Rights Act. That's tab 11 in volume 1. The principal issue in Aston Cantlow, which was about obligations to pay for repairing chancels, was whether or not, or one of the issues was whether or not the church body that was the public authority, but Lord Nichols, paragraph 6, made some general statements about the nature of the Human Rights Act 1998. So in the present case, the statutory context is all important. As to the broad purpose sought to be achieved by section 6.1 is not in doubt. The purpose is that those bodies for whose acts the state is answerable before the European Court of Human Rights, so pausing there, the European Court of Human Rights may attribute to the state acts which would not necessarily be attributed to the state at common law. That was perhaps slightly my diversion. It is an autonomous approach, shall in future be subject to a domestic law obligation not to act incompatibly with convention rights. So there is a domestic legal obligation, and he doesn't say statutory duty, because it is not necessarily a statutory duty owed to individuals. It is a statutory obligation, a legal obligation placed on the public authorities to maintain the standards set
under the ECHR jurisprudence. If they act in breach of this legal obligation, victims may henceforth obtain redress from the courts of this country. So again, it's not a matter of legal entitlement. Your relief is not a matter of legal entitlement. It is you have the opportunity to seek redress in this country, and that's reflected in the language of the HRA 1998. If one looks at tab 1, and in particular (6.1) just says it's unlawful for a public authority to act in a way which is incompatible with a conventional right. 8.1 says, in relation to any act or proposed act of a public authority which the courts finds is or would be unlawful, brackets under the ECHR jurisprudence, it may grant such relief or remedy or make such order within its powers as it considers just and appropriate. So it has something in the nature of an equitable discretion as to whether to grant satisfaction in vindication of a breach of the public authority's obligations. And 8.3, no award of damages is to be made unless taking account of all the circumstances of the case, the court is satisfied that the award is necessary to afford just satisfaction to the person in whose favour it is made. So again, like an equitable remedy, whether or not it is to be granted is judged at trial after there has been an inquiry into all the circumstances, and only then...
Like any case. Nothing to do with equity.
Well,
it's an exercise of a judicial discretion.
Well, my lord, the distinction that's made certainly in equity cases between an entitlement in the circumstances, which is only determined at trial, and what would be more commonly known as a common law cause of action, which is if you establish certain facts and plead those facts, then you are entitled as
Section 8 that says you have to have a trial.
Well,
so what do we look at next?
I mean, equity really is a red herring here, isn't it? I mean, this is the United Kingdom statute. It's not one confined to England. And equity is, it's an important part, obviously a critically important part of English law, but I mean, that would not be the same north of the border with Scotland. And this section doesn't use the word equity. What we do have is a slightly puzzling reference to the word equitable in section 7, subsection 5. I mean, that's a different matter.
Well, my lord, I was only pointing out the nature of the inquiry is to establish all the circumstances, and then it's a matter of discretion whether or not to award a relief.
Well, discretion is the wrong word. I mean, it's not a discretionary relief, is it? Or at least, of course, the court has a number of options open to it, and it must act in a way which is just and fair. But
I'm not sure whether where you get to with your argument is that it's never appropriate to deal with a Section 5 defence, if I can put it like that, on a summary basis. Or do you accept that there are some cases where it would be so clear when a summary disposal is applied for that it would not be equitable at the end of the day, but the case can then be disposed of on a summary basis?
Because section 7.5b refers to all the circumstances, and you will only establish all the circumstances at trial, and I think it was, for instance, it was common ground between my learned friend and myself at first instance that the merits of the case are relevant circumstance to section 7.5b, and one will only fully establish the merits of the case at trial.
Well, you deal with the summary application, assuming the pleaded claim is correct.
Well, my lord, yes.
You can't do better than that.
No, and my lord, if there's no arguable claim, then clearly that can be dealt with at a summary basis. But if there is
if there's no claim under the, it's perhaps a slightly different point, but if there's no claim under the Act, then there's no basis for exercising the juris.
No, well, we're positing here pleadings which do appear to raise an arguable claim, but where the defence is, well, even if you make good your claim as you've pleaded it, it would be barred by the time period, by the delay.
Well, my lady, the circumstances in which you would not have a trial is where it would no longer be possible to have a fair trial. And that is something that is often, and that's why I think there's reference to Section 33, because those are often the considerations one's looking at under Section 33.
Right, so what's the answer to my question? Because I thought that in your first response to my question, you were saying that it's never appropriate to deal with an arguable claim, to dismiss an arguable claim on a summary basis because of the Section 7.5 defence. But are you now saying, well...
My lady, I think I was going to go on to say that if you can say on a summary basis you can't have a fair trial, then obviously you can't have the trial. So you can't, if you can't have a fair trial, you can't decide what all the circumstances are at trial. But the way you decide whether or not you can have a fair trial is you identify what the issues are in the case, which may often require pleadings. And the evidential burden effectively then shifts to the defendant to say, look, I can't deal with this issue because the delay has meant that I haven't got this X evidence or Y evidence, and that prevents a fair trial. But one looks at that question in light of what evidence is available and whether the lack of that evidence really prevents a fair trial. For instance, one might need to have disclosure. And particularly in this case, we don't...
Before we go on, is there any authority at all in support of that proposition?
My Lord, that's certainly there's certainly Section 33 authority.
No. On Section 7.5, that you effectively, this would only operate if you can't have a fair trial, and in order to get that far you'd have to identify all the issues, and then, as you put it, the burden shifts to the defendant to say, well, I haven't got evidence on issues X or Y, and you'd have to then look at it by reference to what the evidence is. And my question is there any authority that says that's the approach under 7.5?
No. My Lord, what there is authority is that under no circumstances should the court gloss the words of Section 7.5.
Well, that I do follow, and the words are such longer period as the court or tribunal considers equitable.
My Lord, yes, and there's an additional word which I particularly rely on, which is the word or. At the end of Section 7.5a.
Well, we know that 7.5a doesn't apply because the claim was not brought within a year.
Yes, but my Lord...
So then we're then into B in any event.
Yes, but my Lord, the reason I place the emphasis on or is it's a perfectly legitimate way to proceed. Either you can proceed as of right within 1 year, or if you're beyond a year, you can proceed if the court considers it's equitable for you to do so, having regard to all the circumstances. One of the ways we say the judge went wrong was to say effectively that Section 5a is a limitation period of 1a, and Section 5a is a limitation period of 1 year. And presumptively, the Crown has the benefit of that. And B,
Well, leave aside the presumptive and somebody having the benefit of it. Do you say it's not a limitation period of a year? But before you get on to the or, which of course is quite right, you have an or. So there is a limit alternative way of looking at it, but the starting point is there's a period of a year
in which you can make the claim as of right. You're only entitled to.
It doesn't say that. We must not gloss the words. The period of 1 year beginning with the date on which the act complained of took place.
Why do you say 1 year was specified by Parliament?
Well,
If it's not intended to be some form of limitation.
Well, my lord, in my submission, it's not for the court to speculate.
So we have to go through any statute by reading it as a whole and looking at its language. And we see here the Parliament has expressly started off by telling us that you have 1 year within which to make this claim. And if your argument was correct, why would we need the A at all? It would just say proceedings under subsection 1A must be brought within such period as the court or tribunal considers equitable, having regard to all the circumstances.
Because then there would never be any entitlement to bring the claim. You'd always be, any claim would be subject to the court's discretion as to whether or not you allow. Parliament has balanced a period in which you're entitled to bring the claim.
But you bring a claim, but if the claim was rubbish, the court would strike it out. Yeah. So you don't get any further forward. We have to look at 5A and B as dealing with time.
Yes.
So this is all about time. The starting point is a year, and then you've got B.
Yes, and my point, my lord, was simply that it is all. You then have B, which has no long stop, and does, again, in my submission, use the language of equity. And in my submission, there is an analogy between the remedies that are available under the ECHR and equitable remedies. In a real sense, what the court is trying to do when it gives just satisfaction is restore the party to the position it ought to have been in, insofar as it is able to do so.
Subject to when the claim was brought. This is not equitable as in the merits of the claim. This is equitable relating to such longer period.
Well, my lord, one of the circumstances, all the circumstances, there is no limit to what can be taken into account.
Of course. And we have your claim, and for the purposes of this argument, certainly speaking for myself, I'm quite prepared to accept that we have to approach it on the basis that the entirety of the pleaded claim is correct. And as I put to you before, you can't do better than that.
No, my lord.
So I agree with you that you, in any strikeout in relation to limitation or indeed any other kind of strikeout, you have to assume that the claim, which is usually the document that people are seeking to strike out, is correct.
But my lord, what the judge did in this case was also to pay some regard as to what defences might be able to be raised.
He did in relation to one point, because there's this novus actus point, and he was measuring one element of it by reference to that. But doubtless you'll come on to that. But just looking at the statute and trying to approach it, the position must be that to the extent that the merits are relevant, then your claim is assumed to be correct in every particular.
But my lord, it may not just depend on how good a claim it is. It might how egregious the interference was, for instance, might be a relevant factor.
It would be contrary to the overriding objective for every claim to go to trial simply because of the use of the word all the circumstances. That just can't, as a matter of case management, you stub your toe on that as a proposition.
Well, my lord, in my submission, that is where
I think the electoral analogy is perhaps useful because that is precisely what happens with a Leahy's defence or with a similar sort of claim for an extension of time under the 1975 Act. And that point was made in Cowan in the recent case. But it was, again, another unfettered discretion.
But Leahy's is where that you're in time, but because of the delay, it's a defence.
Well, you are in
Complete
time.
opposite here, where on one view of 5A, you're out of time, and it's a question of whether the test under B is satisfied.
Well, my lord, because one looks at all, in my submission, the court is only looking at B, and B has no long start.
B in the context of A, A's not been fulfilled, so we go to B. You can't start at B. You can't ignore B. You can't ignore the fact that there's a failure to bring the claim within a year.
Well, my lord, I think that there's a danger if one does that for doing what I think
Because
Lady Hale was
if you
cautioning
ignore
against.
A, as my lord says, you're then not construing the statute.
Well, my lord,
The first rule of construction has to be you construe the provision as a whole. And we're construing subsection 5 in the context of the section as a whole, in the context of the Act as a whole. And you can't just tell us to focus on 5B to the exclusion of everything else.
well, my lord, my lord, in my submission, it's dangerous to try and construe the provision because it
That's
is.
what we have to do.
Well, my lord. Well,
Dangerous territory.
Well, my lord-
Turn back and don't go ahead.
my lord, that. But as a court of justice, it is
Yeah.
It is a perfectly acceptable provision. The court is very familiar with exercising this sort of discretion. And my lord, if I can.
But mustn't all the circumstances include how far out of time you are?
Yeah.
Now, you are, 4 years and some days late. If A had said the period of 4 years beginning with the date on which the Act complained of, and you were standing there saying, but we only missed it by 2 weeks, therefore, that's one of the circumstances that should be taken into account in 5B, do you not accept you'd be in a different position and a stronger position than you are because A says 1 year and not 4 years, and therefore you're substantially out of date rather than only a little bit out of date?
Well, in my submission, that is making assumptions about the purpose for which A is there, which is inappropriate in the circumstances. Because as Lady Hale, in A and Essex, 24, and her observations that were approved by a majority in Rayburn.
So A, B, Essex you want us to go to.
Yes, tab 24 in bundle 1.
This is the one where different permutations of their lordships agree and disagree about different elements of their judgment.
I'm only taking you to her observations because these observations were referred to in the later case of
So which
of Rayburn.
paragraph?
116.
Could we look at 114 too, where she
Yeah.
actually discusses the word equitable, which might be relevant? Must mean fair to each side.
My lord, yes.
Yeah.
I hope that doesn't have any different meaning in the law of equity.
Well, I think the law of equity is a complete red herring. We just want to get away from it. It's
Well,
got nothing whatever to do with this.
Well, my lord, the reason I say it's not a red herring is because there is a question as to whether it is. There are administrative discretions, which is where there are a number of different outcomes, and it is the decision maker who takes into account the relevant factors, perhaps applies a policy or a practice,
but it is his decision as to what the outcome is. And if he takes into account the right things, and he
So, I mean, are you saying a court in Edinburgh applying section 7.5 has to look at the English law of equity in order to reach a decision on whether to extend time or not? I mean, I just don't find that remotely plausible.
Well, in my submission, the only standard that can be applied is justice.
Fair to each side.
Yeah, to each side.
Which is justice.
I've got no difficulty with equitable meaning being fair to each side.
Well, my lord, yes, which is, and when equity considers delay, and this is in my submission where it is relevant. For instance, if one looks back at, or looks at what Lady Howell said in Betterment Properties.
Well, let's just stick for a second to 116.
What she says at 116,
which is a point in your favour,
yes.
I think.
Yes. Because she draws the distinction, which I refer to other cases that draw the distinction between public law aspects, and to a certain extent, this is the Arriva Trains point.
Well, no, the distinction she's drawing there is the need for speed when you're going to strike something down which has prospective effects, whereas here the proposal's already out the window, so we're only dealing here with sorting out damages for past things. It doesn't have any prospective effect, what we're looking at here. So I can see that you would say, well, that's a circumstance in our favour here, as made clear by Baroness Hale at 116.
They're retrospective remedies aimed at marking or compensating what has happened in the past. And this is the point I was drawing attention to. Public authorities are no longer in any different position from other defendants in the law of limitation. There's no longer any sort of crown privilege or deference by the courts. A priori, there shouldn't be in relation to human rights, because if one is starting from the position that one is vindicating human rights, and a public authority has presumptively interfered with somebody's fundamental human rights, it would be odd if one was giving any sort of privilege to the public bodies.
You have to be fair to each side.
Exactly. Precisely, my lord. And if one is being fair to both sides, then the claimant has an entitlement to bring the matter before the court. We know from...
No matter how late.
Yes. Because we know from...
Hang on. So entitlement to bring the matter before the court, no matter how late.
Yes.
Because it's their human right.
Because they're given a statutory right to claim under 7.1.
But how is that different to somebody given a statutory right to claim under the Fatal Accidents Act?
It isn't. And if the defendant doesn't take a limitation point, it can be taken at any time.
But there's no entitlement to bring the matter before the court, no matter how late. If it's statute barred, it's statute barred.
Not unless the defendant takes the point.
Well, that's because it's a defence, not a claim.
Yes, and this is a procedural defence, not a claim.
Yes.
The 7.5 is procedural.
Sorry?
7.5 is procedural.
Procedural?
Not substantive. That's M. That is Lord Justice Thomas, or is it? Sorry.
Lord Justice Thomas in Dunn?
Dunn, probably, yes.
Well, that's where Thomas is, I know. M is Ricks, I think. M's tab 22 and Dunn is 19.
It's perhaps most clearly, the point perhaps most clearly
Where
made
you
at Rick's at 20, tab 22, Rick's in M and the...
yes.
7.5 of the ECHR reckons that the language that is dealing with a time limit, just like any other limitation time limit, recognise that the limitation time limit may be stricter than the time limit imposed by 7.5 itself.
I'm sorry, which paragraph are we at?
19.
No, 19, thank you.
Yes.
The jurisdiction of the court is granted by 7.1, without which, admittedly, the court would not have jurisdiction.
So, where are you reading from now?
Paragraph 19, tab 22.
Oh, the second sentence, yeah.
The subsection 5 is a limitation defence in the ordinary sense of that term.
Yeah.
There is no essential difference or difference at all, other than a slight difference in language between saying things must be brought and saying that the action must not be brought after the end of.
Saying the same thing.
And the limitation earning of an action shall not be brought after. It's just two ways of saying the same thing. This is emphasised strongly by the concluding words of 7.5. That's direct reference to the possibility of limitation at time limits being stricter than the time limits under 7.5 itself. And it is therefore a Section 7.5 is a procedural defence that must be raised by the defendant rather than...
Well, here it has, I think.
That's the point that's made at 20, yes. But in terms of fairness, I was addressing my Lord Justice Coulson on fairness to the parties. And from the claimant's point of view, they have a substantive right to bring the matter before the court under 7.1.
As I say, no different to any other claimant.
No, exactly.
And then limitation defence is raised. And as Lord Justice Ricks points out at paragraph 21, there's no difference between 7.5 limitation and limitation in the Limitation Act.
In terms of its... 7.1 is provides the jurisdiction, 7.5 is a procedural defence. But if one is being fair to both parties, then the starting point is that the claimant has a right, which it is the duty of the court to adjudicate. The defendant then says, it is not fair to me for the court to adjudicate that claim.
No, that, I'm afraid, I'm speaking for myself, Mr. Adams, that's from your skeleton. And speaking entirely for myself, that is glossing, not only glossing the words in the Act, but turning them round.
Upside down.
It doesn't say that the defendant then has to show that it would be inequitable for the defendant.
Well,
my Lord, both Dunn and M say the burden is the normal burden on someone who wishes to persuade the court to adopt an approach to its discretion which she's advocating, if you're under 7.5b.
Well, my Lord, that is, in my submission, that is a gloss. That was accepted by counsel in that case and is inconsistent with Dunn. Whereas, and there are also comments in
Dunn. Dunn is where it's set out. In paragraph 33, Dunn, Lord Justice Thomas sets out the cases that were referred to, and he sets out that passage.
But my Lord, all the cases at 33 are predicated by the words at the beginning of section 30 of paragraph 33.
Yes. He doesn't suggest any of them are wrong or...
Well, he says, what he says
expressly picks out these bits.
And what he's, for the purpose of saying, which is the first sentence, the three first instance cases cited to us might at first sight indicate a more prescriptive approach. So he's saying these patches may show...
but on analysis they don't, and he sets them out.
But he says, on analysis, I do consider that any of these decisions did more than highlight the factors that the judge thought of greatest weight in the facts of the case. So he was saying those are decisions on their facts. They do not establish any principle.
But Cameron has been referred to, and that passage has been referred to throughout, in all of these cases.
Well, my lord, I don't think...
Are you saying it's wrong?
Well, my lord, it is inconsistent with what's been said
Are
in
you
the Supreme...
saying it's wrong?
Well, my lord, it is, insofar as it...
The presumption has to be that the burden is effectively on the party who wants a longer period than a year. Do you say that's wrong?
I do say that's wrong, yes.
That's what I thought you would probably have to.
And my lord, I rely in particular on what was said in the Supreme Court in by Lord Carr in A.N. Essex at 167.
That doesn't say it's wrong. It simply says that it would be an unusual case of this sort that was decided simply by reference to the burden of proof.
He says he prefers not to approach it on the basis of...
Well, one understands that.
There's few cases of this type lend themselves to ready resolution by the application of the burden of proof.
A.N. Essex, paragraph 167.
Tab 24, paragraph 1.
Thank you. Yeah.
You say, few cases of this type lend themselves to a ready resolution by the application of the burden of proof, and I prefer to approach the question, as did the judge, by an open-ended examination of the factors that weigh on either side of the argument, that this is a case in which the discretion of the court should be exercised to extend the time under section 75B.
So not a burden on a defendant to show why it would be inequitable for there to be a trial.
No, my lord, and I still...
Open-ended examination of the factors.
My lord, yes. So the starting point in my submission is that the claimant has the right to bring the matter before the court, and the court then, being fair to the defendant, considers whether or not the claim should be permitted to proceed. And my lord, that is why I come back to Leitch's, because there is a logical reason for the approach of a court of equity to Leitch's. And if one looks at tab 29, which is betterment...
Yes, but I mean, Leitch's only comes into the picture where you don't have a statutory time limit. Here we do have a statutory time limit, plus a discretion to extend it. And I can't for the moment see why the approach of the court on the issue of Leitch's should really help us.
Well, my lord, and I perhaps already made the point, but this is the point. That is presuming that A is a primary time limit.
Well, that's what Lord Justice Rick said in the case you took us to a few minutes ago. He said this is a limitation provision, which it obviously is.
Well, my lord, that B, which is all B,
yes,
has no time limit.
Well, such longer period. So there's there's a discretion to extend the period by reference to all the circumstances.
But there is well, it's all such other period as the court considers equitable.
Other than 1 year. So the context is you have a 1 year limit, which would, if one stopped there, be conclusive. You would have to bring your proceedings within 1 year or not at all. Then you have a let out, which is an extension at the discretion of the court, having regard to all the circumstances. I mean, that's a familiar type of situation, very closely comparable to Section 39 is the Limitation Act. I mean, whichever section it is that allows you to extend the personal injuries.
Well, my lord, if one does look at, we haven't got time to look at all the wording of the different sections, but those are very much drafted as primary limitation period and then exceptions, which is why the word "or" is important in this case, because it makes no sense. There's no logic to a year
as being, for the reasons that Lady Hale has said in A and Essex, you know, there's no obvious reason for expedition. So to presume that Parliament has some sort of intention in those circumstances is, in my...
It would depend. Sometimes there is a need for expedition.
And
Yeah.
anyway, I mean, all limitation periods are...
if it's more in the public law nature.
That's because there's an interest in litigants getting on with it and not sleeping on their rights and on the need of parties to know where they stand for claims to be brought within a reasonable period, etc., etc. I mean, that's the whole purpose of the law of limitation, isn't it? And from one point of view, you could say the period of 1 year strikes a balance between the 3-month period for judicial review on the one hand and the normal 6-year period for tort or contract claims on the other.
Well,
Parliament has decided, and it's not for us to question the reasoning that led them to this conclusion, but Parliament has decided you were to have a 1-year period with a possibility of extension.
my lord, I think my answer to that is, as Lady Hale identified in A and Essex, and as, for instance, Lord Justice Laws identified in Faulkner, some cases are going to be analogous to public law cases, where one is challenging a public decision in the nature of more in the nature of a judicial review. Other cases, and he draws this express distinction, are more in the nature of tortious decisions, tortious claims, where a wrong has been committed historically and the party is seeking relief. Now, it's quite understandable that because some claims might be more in the nature of public law claims and more in the nature of judicial review type claims, that there is a relatively short time limit within which you're entitled as of right to bring the claim. But as Lady Hale says, if there aren't such public law considerations, it's not at all obvious why the claim has to be brought promptly. And indeed, there's a whiff of Crown privilege.
Well, I don't... Where does that come from?
Well,
Where does promptly come from?
Well,
It's a year.
but the normal time limit, well, the normal time limit...
The claimants in Brea made this claim within the year.
I think there might have been one or two who were outside the time.
Right. The vast bulk of them made their claim, this claim, within the year.
As they were entitled.
Yeah. And whether that's could be fairly described as prompt, perhaps isn't for us. The period is a year. That's 4 times longer than you get for JR.
But that there's the dichotomy. There's 3 months. There's the public. If it's a public law case, then it needs to be probably might even be, should perhaps be brought even quicker. If it's not a public law case, it's a tortious case, then there's no obvious reason for expedition. So if one's insisting on expedition, then one's putting in the balance of fairness the interest of the Crown to not to be faced by claims more than a year old.
But we've been told to be fair to both parties, and one of the parties is the Crown. You can't proceed on the footing that the only relevant party is the claimant.
No, I'm saying, but the Crown should be in no better position than any other litigant. And in fact, in some senses, it should be in a worse position because it presupposes that on the face of it, they've interfered with somebody's rights. And I think that is the point that Lady Hale is making in A and Essex. And those remarks were approved by the majority of the court in Raybone. And my lord, I am going to take you to the passage on lay cheese, the famous passage of Lord Selborne, because the reason the equity applies a test of justice is because if you don't apply a test of justice, then you do fetter the discretion with elements of policy or rule, which is precisely what Lord Justice Thomas and Don and the repeated expositions that the section must not be glossed emphasise.
Before we get to the passage from Lord Selborne that I know you're anxious to share with us, does it in 21st century language amount to anything more than an open-ended examination of the factors that weigh on either side of the argument?
No, but it does explain that that delay without prejudice that makes relief unjust to grant relief is not generally a bar to the claim, because the starting point, I do come back to this, the starting point is the court's under a duty to adjudicate the claim. And as the passage in Lord Selborne,
The court is also under a duty to operate 7.5.
but it has an unfettered discretion.
The word is must, isn't it? Yeah. Proceedings must be brought before the end of such longer period as the court or tribunal considers equitable, having regard to all the circumstances, if we leave out A.
Yeah.
So the court has a duty to apply that time limit.
Well, in my submission, it's wrong to describe it as a time limit because there is no. It is open.
Well,
there is no limit.
You that's sufficient to my lord, but that's a separate point. That is the obligation on the court.
And my lord, the passage I refer to in Betterment is again Lady Hale, tab 29, volume 2.
And you must tell us where the Selborne quotation is to be found, even if we, at some point.
Yes,
Sorry,
it's in this.
I deprived you of the citation from Lord Selborne.
It is in. It's in the same paragraph, paragraph 31, tab 20, tab 29. Refers to.
Which paragraph of Betterment?
Sorry, 31, my lady.
That's you.
According to Snell's equity, mere delay, however lengthy, is not sufficient to bar a remedy. And this is not the place definitively to resolve that debate. We're concerned with analogies rather than direct application of the doctrine. Nevertheless, the general principle is that there must be something which makes it inequitable to enforce the claim. This might be reasonable and detrimental reliance by others on or some sort of prejudice arising from the fact that no remedy has been sought for a period of time, or it might be evidence of acquiescence by the landowner in a current state of affairs. In Lindsay Company, Petroleum Company and Hurd, the judgment of Morgan by Lord Selborne contains the following off-quoted passage. Now, the doctrine of laches in courts of equity is not an arbitrary or technical doctrine. Pausing there, what he means is it is an unfettered discretion. It is not bound by rule or by, and is not subject to the subjective arbitrary decision of an individual judge. It is not measured by the length of the Lord Chancellor's foot. It is what is demanded by justice.
That doesn't mean it's a matter of arbitrary justice. I mean, even supposedly unfettered discretions, and the courts will usually lay down guidelines as to their exercise, so that they don't, precisely so they don't become totally unpredictable.
And I think, as was said in one of the, I think it was by,
Sorry, I didn't want to start your...
No, your lordship's reminding me that there is there's, looking at the Inheritance Act cases, which is not a dissimilar provision.
Yeah.
Where there is a short time limit for particular reasons, and
yes.
then an open-ended discretion.
Well, I agree. I think that is a complex context in some ways.
Then I think in Smith and Loosely, it was
I can't remember, sorry, the particular Lord Justice has escaped my mind, but explained it would be positively dangerous to lay down any principles. It is an unfettered discretion. Whenever a court sets out factors, it is only identifying, as Lord Justice Thomas says in Dunn, things that would generally be taken into account, but the court cannot. If it laid down principles that had to be applied as a matter of practice, it would be fettering its discretion, which would be dangerous.
But if that is the right approach, how are you able to attack the decision of the judge in the present case?
Well, I say the judge in the present case, first of all, if he was wrong on A1, P1, I say he shouldn't have tried to decide it when he did, because the merits are relevant to the exercise of discretion. So on the face of it, all the circumstances would only be determined at trial. But if it's going to be said that there cannot be a fair trial, then at the very least, the judge should have allowed the issues to be identified in the case. We don't know yet how the defendant was going to plead justification, for instance. The court would then want to know what evidence was available, because your lordships will recall that in this case, when we wrote our letter of action, the department said, we'll take a limitation point, but even if you get in, we want to stay until after the trial, and we'll deal with your claim after the trial. But as soon as they had the letter before action, they knew what issues were going to arise. They could have started to investigate them if they wished. At that stage, they were preparing for trial in Brea, and they prepared their evidence in Brea and exchanged witness statements, dealing, no doubt, with the common issues that would arise in our claim, as with the other Brea claims, including, for instance, justification. Therefore, one would have to say, what are the issues? What evidence is available in relation to those issues? Is the defendant prejudiced in relation to dealing with any of those issues to the extent that a fair trial is no longer possible? That is a perfectly usual exercise.
But that's the approach that we debated before,
The balance of prejudice.
for which you said there was no authority.
Well,
This is your approach, that this is how you would go about considering these issues.
well, my lord, it's not dissimilar from Section 33, where there's ample authority and there's recent authority, and I put a recent authority in the bundle
It would be
carrot.
terribly dangerous, wouldn't it, to look at that, to translate those across in their entirety,
Yes.
given that we mustn't put a gloss on it and we mustn't fetter anybody's discretion, even by reference to Section 33 and by reference to the dependents' provisions.
But the bottom line in my submission is this is a court of justice. It is duty bound to do justice in the claim before it. The only reason it would not do justice and would not take the matter to trial would be if it was an injustice to the defendant. And in the words of, as I only started Lord Selborne's passage, but at 31, where it would be practically unjust to give a remedy, either because the party has by his conduct done what might fairly be regarded as equivalent to a waiver of it, or where by his conduct and neglect he has, through perhaps not waiving that remedy, yet put the other in a situation it would not be reasonable to place him if the remedy were afterwards to be asserted. In either of these cases, lapse of time and delay are most material. In every case, if an argument against relief which would otherwise be just is founded on mere delay, that delay, of course, not amounting to a bar by any statute of limitations, the validity of that defence must be tried on principles substantially equitable. Now, my lord, where at 1008E, Lady Hale says there must be something inequitable, which makes it inequitable to enforce the claim. In my submission, that is necessarily the flip side of equitable in all the circumstances. Because if it,
So that's the reference in betterment.
because it either is equitable to adjudicate.
No, the reference to Lady Hale is the reference in betterment,
Yes.
which isn't a Section 7.5 case at all.
No, it is how the court should approach delay
Yeah.
if there is no, purely as a question of justice, which is how a court of equity approaches delay.
Yeah. So you say that the question is that you say effectively the question the court should ask itself is it inequitable to enforce the claim,
Yes.
no matter how long the delay?
Yes. Because if it is not inequitable, it is equitable. If one is being fair to both parties.
Are you saying, sorry, do answer.
So let me just make a note of what you said. No matter how long the delay. Yeah, thank you.
I say there's no open ground between equitable and inequitable. It is not a matter of discretion where an individual judge can exercise policy or discretion. Justice demands the claim is adjudicated unless it would be unjust to the defendant.
So are you saying, in effect, that you were entitled to wait until Breyer had run its course? In that course of Breyer, issues that were common to your claim were going to be sorted out, like the test for whether a contract is a possession, like the goodwill point, like whether there was justification. And so that was a reasonable thing for you to do, to wait until then. And that has the benefit of shortening the issues in this case so that Bayes is not prejudiced by the delay, because a lot of ground has been cleared by Breyer. Is that roughly what you're saying?
It is roughly, yes. I would only add that there's a perfectly reasonable explanation as to why we waited. We were chasing other claims.
Right.
Indeed, if one looks at Breyer at first instance,
Breyer, and you were trying to get the money through.
it was argued by the department in Breyer that that's precisely what the claimants ought to be doing. They should be trying to make contractual claims and pursue other remedies. So we effectively did what the department in Breyer was saying we ought to be doing. Now we devoted our resources to those claims. The GBBS became insolvent. We managed to make a modest recovery from Northumberland, who had these panels on their roofs, and now were earning the full feed-in tariff in relation to them without having paid full price for them, which didn't seem right. So, but we reached a settlement with them. And we then turned to a claim against the department. At that time, a year before trial, we probably could have been joined in. But the department's response was,
A, we've got a limitation defence, but B, even if you get over that, we want to stay it until after Breyer. Now, from our point of view, that was a perfectly rational thing to do because nearly all the issues were going to be determined. You know, everybody assumed Breyer was going to go to trial, and that would have sorted many of the issues, as your ladyship says, would have sorted many of the issues, leaving odds and sods.
What issues?
Justification is the issue that repeatedly raises its head, according to the...
I mean, there was a by reference to the preliminary issues, having gone to the Court of Appeal and lost, these were valid claims.
My Lord, I think
The trial in Breyer would have been a nightmare because it was effectively then the facts.
except, my Lord, and I think this is recorded in the order of the Court of Appeal, because the Court of Appeal was decided on assumed facts, the department has run and continues to run a case of justification.
Yeah, there were various elements, but those would have been different depending on the contracts. Come back to that point.
I'm not sure the justification. I think
I think you'll find that there were different depending on the particular contract. But anyway, certainly my involvement told me that the trial, which would have been heard in January 2018, was a smorgasbord of factual and effectively causation arguments, whether the contracts would have gone ahead anyway, all of that. Anyway,
but it was, my Lord, it was the department's suggestion. It was put back behind Breyer, and
yes.
It doesn't lie in their mouth to say that anything that's happened since we wrote the letter before claim has further prejudiced them. If they wanted to investigate our claim, then they could have done, or they could have insisted we pursue it then. It was their suggestion. We put it back behind Breyer, and we reasonably expected.
The claim was
2016.
2016.
That would be a strong point, Mr. Adams, if your letter for action had come more promptly after the proposal had been withdrawn. But there we are.
Well, my lady, that brings us back to whether any weight should be put on mere delay. And the court is only tempted to put weight on mere delay because of some in my submission, because of some sort of statutory gloss on the statute to speculate as to what Parliament's intentions were to put in a one-year period. It is quite understandable.
I'm not at all interested in what Parliament's intentions were. I just know that there's a year in there, and I just know that Lord Justice Ricks said that's a limitation period. I'm not putting any gloss on the approach to the provision other than that.
It is a limitation period because that is the limit. That is the limit in time at which a claim can be brought as of right.
Well, you've made that submission.
Yeah. Well, it's nearly 1 o'clock, Mr. Adams, so are you able to wrap up your submissions now, or...
My Lord, unless there's anything I can assist your Lordships with at 2 o'clock, your Lordships and Ladyship, at 2 o'clock.
Well, by all means, consider your position over the court adjournment. And if you wish to add, literally a few sentences worth at 2 o'clock, I dare say Mr. Weisselberg could live with that. But subject to that, obviously we have your written submissions, and of course we've read the judgment with care. So although you haven't taken us to it, I think you can probably, well...
Yes, well, my Lord, perhaps I might in a few sentences just...
Well, exactly. So I won't stop you continuing for a very short while, just to wrap matters up. But subject to that, I think you've had a good whack on each limb of the appeal, and we're very grateful for your submissions. But in that case, we will adjourn now until 2 o'clock, unless anyone else has any points to raise at this stage. Thank you very much. I suppose we need our masks back.